No questions, Your Honor.
All right. Are there any questions from any member of the jury? Not seeing any, sir, you can step down. You can step down. Thanks.
All right. What did you make of that?
I think it was a valid objection, and I think that she's doing an okay job doing the right thing in representing herself.
All right, fair enough. Let's bring in our guest and find out what he thinks. Trial attorney Rich Schoenstein joins us. And Rich, how do you think she did on cross of this witness? I thought maybe there were a couple of missed opportunities, but I want to get your thoughts.
All right. Well, here she is cross-examining her brother. You know, I have two brothers. I love them dearly. I've never had the opportunity to cross-examine them. That sounds special. But, I mean, her first line of questions could have been summed up in one question. We haven't seen or talked to each other since 2018, right? He would have said, right. That would have shortened this whole examination by about 5 minutes, and we wouldn't have had to hear about green chili chicken enchiladas, which appears she was irritated he didn't remember. But at the end, she missed a huge objection, because I know the scope objection got overruled, and I think the judge was wrong about that. But then the next question was whether or not he believed Alex and Lori conspired to kill her husband. And I'm sorry, but his belief is completely irrelevant and prejudicial. And she should have been on her feet screaming an objection to that question. And instead, he was allowed to answer it. And his answer was damning. That was a bad mistake by her.
Rich, you saw my question, my quote that I wrote down. Michael and I are so far away. I said, now you can't read my questions. And you took it exactly from me, because I couldn't believe that when he was allowed to answer. No doubt in my mind they killed him. It's a feeling I have. We don't care about what feeling the witness has on the stand about what happened. And let me ask you this, because for viewers watching, for appellate purposes, if you don't object, then you lose that point on appeal. However, shouldn't the state still play by the rules, or do you think it's okay to push it as far as they can, knowing she may not know the proper objection?
So the state, you know, it's a really good question, Judge. I mean, I think the state is going to ask the questions it wants to ask and is going to, if it gets a little leeway, utilize it. The bigger question is, what should the judge do? Should the judge step in on a patently objectionable question and cut off the state, even if the defendant isn't? But this whole thing highlights, again, why it is such a terrible, horrible, no good, very bad idea to represent yourself. You know, she's done okay. Her opening was okay. Her questions have been okay. She looks almost competent, but she doesn't know the rules, and she doesn't know when to object, and she doesn't know how to preserve things for appeal, and those are vital things for a trial lawyer.